Hello friends, my name is Harshit Dwivedi and I welcome you all to my audio lecture. This audio lecture is a bit longer one. In this audio lecture I will start from Article 19 of the Indian Constitution till Article 18 of the Indian Constitution and all constitutional developments from the year of 1773 have been told by me and they are available free of cost on my blog gs-india.blogspot.in. In this audio lecture, I will start from Article 19. Now, Article 19 is the right to freedom, which basically is the protection of 6 basic rights of freedom. That is, Article 19 guarantees 6 rights to the citizens of India. These rights are: first one is the right to freedom of speech and expression. Second one is the right to assemble peacefully and without arms, it is precisely right to assemble peaceably and without arms. It means the same, right to assemble peacefully and without arms. The third one is right to form associations or unions or cooperative societies. The fourth one is right to move freely throughout the territory of India. Fifth one, right to reside and settle in any part of the territory of India. Sixth one, right to practice any profession or to carry on any occupation, trade or business. Now these are the basic 6 freedoms which are available to the citizens of India. Now the point here is that these rights are available only to the citizens of India, or you can say to the shareholders of a company. But these rights are not available to the foreigners, that are the citizens of other countries, and they are also not available to legal persons like companies or corporations. It is only available to the citizens of India. Now, this third point, that is the third right, right to form associations or unions or cooperative society. Now this provision of cooperative society, this word of cooperative society, was added to the third clause by 97th Constitutional Amendment Act of 2011. I repeat, this third option, right to form associations or unions or cooperative societies, this third clause was added by 97th Constitutional Amendment Act of 2011. Now here the point is that these 6 freedoms were basically 7 freedoms under our constitution. Originally, a provision of 7 freedoms was made under our constitution, but in Article 19(1), one freedom, which was the right to acquire, hold and dispose of property, was omitted by the 44th Constitutional Amendment Act of 1978, leaving only 6 freedoms left. That is, these 6 freedoms, that is the right of freedom to speech and expression, second one, right to assemble peacefully and without arms, third one, right to form associations or unions or cooperative societies, fourth one, right to move freely throughout the territory of India, fifth one, right to reside and settle in any part of the territory of India, and the sixth one, right to practice any profession or to carry on any occupation, trade or business. These are 6 freedoms, but originally there were 7 freedoms. And the one extra freedom was of the right to acquire, hold and dispose of property, which was removed by the 44th Constitutional Amendment Act 1978. Now the point here is that these, you can say that these 6 freedoms, the state has the power to impose reasonable restrictions on the enjoyment of these 6 rights only on the grounds mentioned in Article 19 itself and not on any other grounds. The point is that these 6 freedoms that I told you, these freedoms are not absolute. That is, that some exceptions, on the basis of some exceptions in accordance with the provisions that are mentioned in the Article 19 itself, going by those exceptions, certain reasonable restrictions can be imposed on the exercise of these rights. Now it is important to know that what are those exceptions. So now I will read what is exactly written in the Constitution of India. Then it will become a bit more clear to you. In the Constitution of India, under Article 19, Clause 1, all citizens shall have the right. And then Subclause A, to freedom of speech and expression. Subclause B, to assemble peacefully and without arms. Subclause C, to form associations or unions or cooperative societies. Subclause D, to move freely throughout the territory of India. Subclause E, to reside and settle in any part of the territory of India. Now subclause F is blank. Subclause F is blank. Now why is this subclause F blank? Subclause F is blank because this subclause F of Article 19(1) has been omitted by the Constitution 44th Amendment Act 1978. What was it? That was a right to acquire, hold and dispose of property. And subclause G, to practice any profession or to carry on any occupation, trade or business. Now here comes the exception. The exception under point 2 notes that nothing in subclause A of clause 1. Subclause A, that means the right to freedom of speech and expression. That nothing in subclause A of clause 1 shall affect the operation of any existing law or prevent the state from making any law insofar as such law imposes reasonable restrictions on the exercise of the right conferred by the said subclause in the interests of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation contempt of court, defamation or incitement to an offence. Now what was this point? This was the exception to the subclause A. What was subclause A? That was the first right to freedom of speech and expression. Now this freedom of speech and expression, this right, on this right some reasonable restrictions can be imposed by the state. If the state thinks that by any individual something is done which is harmful to the interests of the sovereignty and integrity of India, the security of the state, it is harming the friendly relation of India with foreign states, it is disordering public order, decency or morality is compromised, contempt of court is being done, or defamation is being done. If anything, any of these points, if the state thinks that if an individual is using his right of freedom of speech and expression, and in the exercise of his right of freedom of speech and expression, he is doing anything which is against the fabric of the country, which is disharmonizing the friendly relation of the India with foreign states, which is disorienting decency or morality, which is compromising the sovereignty and integrity of India, then the state can confer reasonable restrictions on the exercise of this right. Similar restrictions have been made on the other points also, that is to assemble peacefully without arms, to form associations or unions. Now, under the subclause D and subclause E, the subclause D read, to move freely throughout the territory of India, and the subclause E read, to reside and settle in any part of the territory of India. Now, there is a point under point 5 which says, nothing in subclause D and E of the said clause shall affect the operation of any existing law insofar as it imposes or prevent the state from making any law imposing reasonable restrictions on the exercise of any of the rights conferred by the said subclauses, either in the interests of the general public or for the protection of the interest of any scheduled tribe. So the point is that this right to move freely throughout the territory of India and the second right to reside and settle in any part of the territory of India, on these rights certain reasonable restrictions can be imposed by the state if the state is convinced that the exercise of these rights by individual is not in favor of the public or it is not in favor of the scheduled tribes. Obviously, the scheduled tribes, a lot of scheduled tribes are found in India and they are distributed across various states, and in order to protect their culture, in order to protect their place, certain reasonable restrictions can be imposed on subclause D and subclause E, that is, on the right to move freely throughout the territory of India, which is subclause D, and the subclause E, that is, to reside and settle in any part of the territory of India. Reasonable restrictions can be placed on these 2 points in order to protect the interests of the scheduled tribes of the country. The next point. Hello friends, I welcome you again. Starting from where I left my previous lecture. In the previous lecture I told you all the 6 freedoms of Article 19(1). Now after these 6 freedoms of Article 19(1), I was telling you that what are the exceptions involved through which the state can impose reasonable restrictions on the enjoyment of these rights by the individuals. And I have told you the reasonable restriction relating to subclause A of clause 1 of Article 19, that is freedom of speech and expression, and also of that suitable reasonable restrictions were also applicable to the subclause B, that is to assemble peacefully and without arms, also to subclause C to form associations and union, and in relation to the subclause D and subclause E, I also told you that these rights can also be imposed with reasonable restrictions for the benefit of the general public and also for the benefit specifically for the scheduled tribes. Now coming on to the very next important point, we have to get to know that when it comes to the subclause G, that is to practice any profession or to carry on any occupation, trade or business. So the point is why I am saying subclause A, subclause B, subclause C, subclause G. The reason for me using this subclause is that in these articles, these provisions have been mentioned in the Constitution of India in this form only. That is, these 6 points have been written in the Constitution of India in the form of subclause A, subclause B, subclause C, subclause D, in the same manner and form in which I am telling. Now, the very last, that is the subclause G, that is to practice any profession or to carry on any occupation, trade or business. Now this one, on this right, the state can impose reasonable restrictions on the exercise of this right in the interest of the general public. The state is empowered to, point A, prescribe professional or technical qualifications necessary for practicing any profession or carrying on any occupation, trade or business. I would repeat, point A, prescribe professional or technical qualifications necessary for practicing any profession or carrying on any occupation, trade or business. Second point, carry on by itself any trade, business, industry or service, whether to the exclusion, complete or partial of citizens or otherwise. Thus, no objection can be made when the state carries on a trade, business, industry or service either as a monopoly, it may be a complete monopoly or a partial monopoly, to the exclusion of citizens, whether all of the citizens or some of the citizens, or in competition with any citizen. The state is not required to justify its monopoly. Also, this right does not include the right to carry on a profession or business or trade or occupation that is immoral. Immoral, that is operations like use of harmful drugs or explosives, child trafficking, bonded labor. The state, that is the government, can absolutely prohibit or stop these professions, or they can also regulate these professions by licensing them. So this was what basically Article 19. Now here are some manifestations of these Article 19 rights, 6 freedoms. I will like to read them in front of you. Even though the constitutional freedom of speech and expression is not absolute and can be subjected to reasonable restrictions on grounds such as decency and morality. Flying of national flag is a symbol of expression coming within the preview of Article 19, 1 subclause A. A voter's speech or expression in case of election would include casting of votes, that is to say, a voter speaks out or expresses by casting vote. Right to information is an integral part of freedom of expression, particularly a voter's right to know the antecedents, assets of a candidate contesting elections. Right to speech implies the right to silence. It implies freedom not to listen and not to be forced to listen. The point here is that whatever statements that I am saying here, these are the judgments of Supreme Court in various cases. Under various cases, several public interest litigations have been filed in Supreme Court, and Supreme Court has at several times gave its verdict on those litigations. And on the basis of those litigations, some very important landmarks, some very important statements have been given by the Supreme Court. So these are those statements, which in the very first I said that flying of national flag is a symbol of expression which comes under the preview of Article 19, Clause 1, Subclause A, that is freedom of speech and expression. Also, the freedom of speech and expression also includes the voter's speech or expression in the case of election, in which the voter casts his votes and tells us that to which candidate he wants to give his vote. Right to information is also an integral part of the freedom of expression, particularly a voter's right to know the antecedents, assets of a candidate contesting elections. Right to speech implies the right to silence. All I have told you. Now, next point. The dignity of the courts and the people's faith in administration must not be tarnished because of biased and unverified reporting. In order to avoid such biased reporting, one must be careful to verify the facts and do some research on the subject being reported before a publication is brought out. Giving of a call for bandh and its enforcement by any association, organization or political party would be illegal and unconstitutional. So the point is that if we define the limitations upon these freedom, we would say that absolute individual rights cannot be guaranteed by any modern state. The guarantee of each of the rights under Article 19 is therefore limited by our Constitution itself by conferring upon the state a power to impose by its laws reasonable restrictions as may be necessary in the larger interests of the community. This is what is meant by saying that the Indian Constitution attempts to strike a balance between individual liberty and social control. Since the goal of our constitutional system is to establish a welfare state, the makers of the Constitution did not rest with the enumeration of uncontrolled individual rights in accordance with the philosophy of laissez-faire. Now, what is this philosophy of laissez-faire? Laissez-faire, I will spell laissez-faire, it is L-A-I-S-S-E-Z, and fair, F-A-I-R-E. Now, what is this philosophy of laissez-faire? The philosophy of laissez-faire says that laissez-faire is an economic environment in which transactions between private parties are free from government restrictions, tariffs and subsidies, with only enough regulations to protect property rights. That is, there is no government restriction, there are no government tariffs and no government subsidies. But regulations are there to protect property rights. So, in accordance with the philosophy of laissez-faire, but sought to ensure that where collective interests was concerned, individual liberty must yield to the common good. But instead of leaving it to the courts to determine the grounds and extent of permissible state regulation of individual rights, as per the American Constitution does, the makers of our Indian Constitution specified the permissible limitation in clause 2 to clause 6 of the Article 19 itself. Now, what does this mean? This means that what the goal of our constitution was, the goal of our constitutional system was to establish a welfare state in which all the citizens are in good health and in good social, they are basically in good social and economic health. Now the point is that the constitution did not follow the philosophy of giving uncontrolled individual rights to the citizens of India in accordance with the philosophy of laissez-faire. That is an economic environment in which the transaction between private parties are free from government restrictions, tariffs and subsidies. But they sought to ensure that where collective interests were concerned, individual liberty must yield to the common good. That is, if for a group of persons a thing is good, but maybe for some of those persons that thing is not good, then collective interest will prevail over individual interest. This is the point here. That is, if doing a thing is good for a group of people, but doing the same thing is not good for some people that are belonging to that group, then in that clash, the collective interest will be taken in account. This is the point here. So, the Indian Constitution didn't follow the philosophy of laissez-faire and it didn't provide uncontrolled individual rights to the citizens of India. However, there is one difference from the American Constitution in this aspect, that in the American Constitution, what is good and what is the extent of permissible state regulation, that is, in America also the state can impose reasonable restrictions on the rights enjoyed by people. But whatever the restrictions that will be imposed on the rights of people will be decided by the courts of America. But in India, this responsibility of deciding the amount of reasonable restrictions on the rights of Indian citizens, the courts have not been made responsible, but the constitution makers have specified the permissible limitations in clause 2 to clause 6 of the Article 19 itself. I told you that when it comes to the Article 19, clause 1, subclause A, freedom of speech and expression. Now, freedom of speech and expression, the exception was covered in clause 2. From clause 2 to clause 6, exceptions are told. I told you that in this article 19, these articles have been provided to the citizens of India. But also, the exceptions to the application of these articles have also been provided in this article 19 itself. And they have been provided from clause 2 to clause 6 of the article 19 itself. In these clause 2 to clause 6, it has been written that what will be the exceptions. I told you this in the previously I told you this in this audio tutorial only. That when it comes to the subclause D and subclause E, that is moving inside the territory of India, that is this movement can be imposed or restricted by the state if it thinks that it is against the general public, or if the government or the state thinks that it is against the interest of the scheduled tribes people. And things like these I told you the exceptions previously in this audio tutorial. Now with this we finish the article 19 of the Indian Constitution, and now we will move on to article 20 of the Indian Constitution. Now the title line of the article 20 reads, protection in respect of conviction for offences. Article 20 grants protection against arbitrary and excessive punishment to an accused person, whether citizen or foreigner or legal person like a company or a corporation. This article 20 contains three important provisions. The three important provisions is first one is no ex post facto law. The second one is no double jeopardy. The third one is no self-incrimination. Now what is an ex post facto law? An ex post facto law is one that imposes penalties retrospectively or retroactively, that is upon acts already done, or which increases the penalties for such acts. The enactment of such a law is prohibited by the first provision of Article 20. The first provision of Article 20 says that no person shall be, point 1, convicted of any offence except for violation of a law in force at the time of the commission of the act. Second point, subjected to a penalty greater than the prescribed by the law in the force at the time of the commission of the act. Now what does this mean? This means that suppose a man commits a crime at this point of time in 2014. Now if a man commits a crime in 2014 and for that crime at this point of time there is a prison term of 5 years. Now if suppose a man A has committed a crime in 2014, and if in 2016 a law has been made in which the jail term of the same crime has been extended up to 10 years. I said that in 2014 for a crime the jail term was 5 years, and if in 2016 the jail term is 10 years, then if a person has committed the crime in 2014, he can be given the jail term of maximum 5 years only. That means if the prosecution of that criminal goes on for 2 years, then if in 2016 a law is passed which increases the prison term of the same crime by 5 years, that is from 5 years to 10 years, then that person who has committed a crime in 2014 cannot be sentenced to a prison of 10 years because he committed the crime in the year 2014, and in the year 2014 the jail term for that punishment was 5 years. It was not 10 years. It was being made to 10 years in 2016. So the point is that it says that no person convicted of any offence except for the violation of a law in force at the time of commission of the act. This is what it says, that when you are committing an act is being committed by you, and when that act is being committed by you, then at that time the law which will be in the force, that will be applicable, not a law that is made after 5 years or after 10 years. This is the first point. The second point says that no person shall be subjected to a penalty greater than prescribed by the law in force at the time of the commission of the act. The point is that I have explained both of these provisions to you in one thing. This is the same thing. I told you the example of a criminal, and by saying the example of the criminal, I have told you the whole provision 1 of Article 20. That is no ex post facto. I will repeat it to you again. It says that a person cannot be convicted for breaking a law which is made in the future. If a criminal has committed a crime now, and that crime has broke a law which is presently in force, if that type of law is not presently in force and it is made in future, then for the law that is made in future, that criminal cannot be held responsible. Also, if the penalty, suppose if the prison term of breaking a law is 5 years in 2014 and the criminal has committed the crime in 2014, and if the prison term is increased to 10 years in 2016, and if the prosecution of the criminal goes on till 2016, it cannot be possible that the court sentences that that criminal to a prison term of 10 years in 2016. He can be sentenced to a maximum of 5 years of only, because he committed the crime in 2014, and in 2014 the penalty of that crime was 5 years. This is one simple example to understand this thing. Now, second point, no double jeopardy. This says that no person shall be prosecuted and punished for the same offence more than once. If a person has been punished for a crime that he has committed, then he will be punished for that crime only. This means that if a sentence has been awarded to a criminal, suppose a criminal commits a crime, and for that crime he has been sentenced to a jail of 10 years. Now, after he has met that jail term, he cannot be sentenced for another 5 years for the same crime. That is, no person shall be prosecuted and punished for the same offence more than once. This is the second provision of the article. Now, two provisions I have told you regarding the protection in respect of conviction of all offences. That is Article 20 of the Indian Constitution. Now, the third provision, that is a provision of no self-incrimination. Now, what is this self-incrimination? We should understand this provision of self-incrimination by an example. Suppose a person commits a crime and he has been convicted, he is being prosecuted for that crime. Suppose a case is being going on in the court against him. Now, if a lawyer says to a person that you yourself say against you, that is, you yourself be a witness against you, that is, a person is being compelled to give a proof of the crime by himself accepting that he has done a crime. Suppose a person who has committed a crime and he is facing a trial in the court, and in the court a lawyer asks to him that whether you have committed a crime, and if in reply that person says that yes, I have committed that crime, then that witness will not be enough for giving a punishment to that person. This is the principle of no self-incrimination. That as a person cannot be self-incriminated. That is, he cannot be a witness against himself. This means that if a person himself says that yes, he has committed a crime, if he says that he has committed a crime, the court will not agree to it, and the persons who are speaking against that criminal, they have to prove it. The law enforcing authorities, the police, they have to prove the crime against that person. Only after the proof against him has been done, then only he will be convicted for that crime. This is the principle of no self-incrimination. That is, no person accused of any offense shall be compelled to be a witness against himself. But there is a small, you can say, exception to it, a limitation to it. That is, the limitation is imposed only on criminal laws and not on civil laws or tax laws. Now all these three provisions are very much interrelated to each other. I told you that no ex post facto law. In that no ex post facto law, I told you that no penalty will be imposed retrospectively. But a small exception you have to keep here in your mind is that retrospective clause, the enactment of that clause, this limitation is imposed only in the case of criminal laws, not in the case of civil laws or tax laws. In the case of self-incrimination, that is the third one, the protection against self-incrimination extends to both oral evidence and documentary evidence. Also, the self-incrimination provision extends only to criminal proceedings and not to civil proceedings or proceedings which are not of criminal nature. So the point here is that you have to understand these three things: no ex post facto law, no double jeopardy, no self-incrimination. What is no ex post facto law? That is that if you have convicted of any offense except for the violation of a law in force at the time of the commission of the act or the crime, or you cannot be subjected to a penalty greater than that prescribed by the law in force at the time of the commission of the act. This is one important point. The second provision, that is the principle of no double jeopardy. It says that a person cannot be punished for the same crime more than once. And also the third point, no self-incrimination. The point of no self-incrimination is very important. In this clause of no self-incrimination, you cannot testify against yourself. That is, if you have done a crime and even if you are testifying against yourself, even if you are being a witness against yourself, even if in the court you are saying that I have committed this crime, then also the court will not believe on you. And it will look for evidence. It will look for a solid documentary evidence, a solid proof which can make you held accusable. That is, your saying that you are a criminal is not enough to get you punished. There should be sufficient documentary and evidence against you. There should be sufficient evidence against you in order to keep you behind the bars. So friends, I hope these three provisions of Article 20 are clear to you. So the point is that in these two audio lectures I have told you only Article 19 and only Article 20. Article 19 and Article 20 have been covered in this. I hope you like this audio lecture, and these two articles are very important. I have, from the examination perspective, I have completed everything. I hope you will like this audio lecture. Thank you for listening to this audio lecture. We'll see you soon. Hello friends, my name is Harshit Dwivedi and I welcome you all to my audio lecture. This audio lecture is a bit longer one. In this audio lecture, I will start from Article 19 of the Indian Constitution till Article 18 of the Indian Constitution and all constitutional developments from the year of 1773 have been told by me, and they are available free of cost on my blog.